Hello, everyone, and welcome to our Top 5 series for Ryerson's alumni and friends. My name is Christian Mehta, and I am the AVP of Engagement at the university. Before we begin, I want to pay my respects to the Indigenous peoples, elders, and ancestors who stewarded and cared for the nature and people who lived on this land that was stolen from them and where Ryerson is located today. At the university, we have made a deep and long-lasting commitment to truth, reconciliation, and decolonization, and I invite you to learn more about this work online and in person next time we can get together on campus. So we know you've got a lot on the go, and this is just a 30-minute webinar. We'll dive in quickly, but before I introduce Jamie Golombek to you, I have two housekeeping tips to share. In about 20 minutes, Jamie will be taking your questions. If you want to ask something, please add your question to Zoom's Q&A area. Your cameras and mics are off, so I'll be selecting questions from there. We are also recording this session, so if you want to rewatch it or share it with your friends, networks, colleagues, and others, please look for a message from us in your inbox over the next day or two. Okay, so on to today's speakers, Jamie Golombek, Managing Director, Estate and Tax Planning with CIBC Private Wealth Management in Toronto. He joined the firm in 2008 after 12 years with a global investment company where he was involved in both internal and external consulting on all areas of taxation and estate planning. Jamie is quoted frequently in the national media as an expert on taxation, writes a weekly column called Tax Expert in the National Post, and has appeared as a guest on BNN, CTV News, and The National. He received his BCom from McGill University, earned his CPA designation in Ontario, and qualified as a US CPA in Illinois. He also obtained his CFP, Certified Financial Planning, and Chartered Life Underwriting designations. Jamie also teaches an MBA course in personal finance at the Schulich School of Business in Toronto. Wow, Jamie, it's a pleasure to have you join us today. Thanks so much for being here, and the next few minutes are over to you.
Well, thanks very much, and thanks to all of our alumni joining us from across Ontario and also from other parts in Canada as well. We've only got 20 minutes, so how can we talk about estate planning, which conjures up images of wealthy estates and remote Caribbean islands with offshore tax planning and trust? How can we do that all in 20 minutes? Well, we're going to try, and what I've tried to do is organize this into 5 easy steps, and we're going to read them to you. And then we're going to go through each of the steps for about 3 minutes each. So number 1, prepare a household balance sheet. Number 2, draw up your powers of attorney and a will. Number 3, plan to minimize taxes, probate, and consider life insurance and other forms of insurance. Number 4, keep track of your accounts, your important information. And number 5, review, update, and share your plan with others. So let's get right into it. Number 1, a household balance sheet. You want to make a list of all your assets and liabilities. You don't have to list every stock or every ETF that you own or every mutual fund. What you want to do is basically have a list of basically your accounts, where they're located, the contact information, the branches, an approximate fair market value. And then the liability side, whether it's mortgages, family member debt, things like that, credit card debt, just a list of approximately balances and the account locations and the account numbers, so that someone looking at your estate knows exactly how much you have, and you know how much you have in terms of deciding how to divvy it up among people you care about. Step number 2, one of the most important steps, is your powers of attorney and your will. Notice that a will is not the same as an estate plan. Estate planning is more comprehensive, but a will is a very important part of an estate plan. So let's begin with our powers of attorney. So powers of attorney in Ontario, for example, we have 2 of them. We have the power of attorney for property, and we have the power of attorney for personal care. Power of attorney for property allows someone else to make financial decisions on your behalf if you're incapacitated. And a power of attorney for personal care allows someone to make healthcare decisions on your behalf in the event of incapacity. With the current COVID-19 pandemic, we are seeing family members or friends sometimes in serious medical situations where they may not be able to act for themselves, which is why the emphasis on making sure that you have a properly executed power of attorney, specifically for personal care, has really come to the forefront in the last few weeks as we've been dealing as a society with the pandemic. Unfortunately, only 1 in 4 Canadians actually have a power of attorney. So don't feel bad if you don't have it, but hopefully today will be a motivator for you to go out there when you speak to your lawyer about doing a will or updating a will. You want to think about also getting powers of attorney. Now, of course, a will is important because what a will does is it forces your executor to follow your instructions. For example, if you die in Ontario, and let's say you've got a spouse and 2 kids, you might think that if you die without a will, your spouse gets all your money. That is not what happens, even if you're legally married here in Ontario. In Ontario, what would happen is your spouse only gets the first $200,000 of your estate. The rest of the money is split 1/3 to your spouse and 2/3 to the kids. And if that's not what you want to do, you better have a will. The rules are similar in most provinces in Canada. So planning a will involves a number of things. It involves naming your beneficiaries, kids, grandkids, nieces, nephews, or perhaps a charitable foundation. It involves naming executors or trustees. If you've got minor kids, naming the guardians for those minor kids. Maybe you want to do some pre-planning to transfer some assets directly, making gifts while you're alive. We'll come back to that. Or maybe naming beneficiaries on things like RSPs, RIPs, TFSAs, and life insurance. And then also talk a little bit about testamentary trust, because that can be an important part of a will. And what a testamentary trust is, it's unlike a corporation, it's not a legal entity, but it is a relationship. And it's a relationship that separates the legal ownership of property from the beneficial use and enjoyment of that particular property. So a trust takes effect only upon death. It's included in your will. And there are a lot of non-tax reasons why someone might use a testamentary trust. So for example, if you've got minor beneficiaries, particularly with large amounts of life insurance, you may not want the kids getting all the money on the day they turn 18. Frankly, we've got clients that wouldn't give the money to the kids on the day the kids turn 40. So in that case, you might want to have a trust in your will that specifies when the kids get the money. In other situations, you're just not comfortable giving kids large sums of money all at once. So maybe in your will, you have a testamentary trust that allows for staged distribution, where you give half the money to a kid at 25, and you give the other half to them at age 35. In other situations, you may have what we call spendthrift beneficiaries. These are beneficiaries that are not good with money, or in fact may have a serious problem, whether it's a gambling or an alcohol addiction, and you don't want to give them full control over the estate. So you put conditions in the will. The money is to be used for education, for housing, for clothing, for food. You don't give them full reign of the money. The fourth one is some people are using a testamentary trust called a matching incentive trust to motivate the behavior of the beneficiary. So we've all seen stories where beneficiaries inherit large amounts of money, and that's it. They drop out of life, they stop working, and they start living on mom or dad's inheritance. So if you want to continue to motivate the kids to do something with their life, you could consider a matching incentive trust. And in such a trust, effectively what happens is you say to the kids, hey kids, if you want to get any money from mom or dad's trust, you've got to prove that you've at least earned the same amount on your own. So every year, a kid would bring a copy of their tax return to the trustee, and if they make $50,000, the trust matches that with another $50,000. If they make zero, they get nothing from mom or dad's trust. So again, parents love the idea, but kids not as much. And then finally, one of the reasons we often see trust is to protect the kid's inheritance in case of remarriage. So typical scenario, spouse A and spouse B, they have what we call mirror wills. So A dies, leaves the money to B, or B dies, leaves the money to A. And on the second to die, the money goes to the kids. I've always been worried about this personally, because what if I leave money to my wife after I'm gone? My wife decides to remarry, and then she dies. She could end up leaving all my money to some new guy who I never even met, or hopefully never even met. And my kids can end up with nothing. So instead, what I could do is set up a testamentary trust in my will, give my wife access to the money while she's alive, but then when she dies, the money's sitting inside the testamentary trust and is available to the kids of the first marriage. You see how there's no arrows anywhere joining the second family, because I've cut them off completely from the value of my estate. So that's one of the things you want to talk about with your lawyer when you're doing an estate plan. Step number 3, plan to minimize taxes, probate, and even consider the use of tax-free life insurance. So what are we talking about? We're talking about probate and income taxes payable. Well, probate varies by province. So again, we have alumni from across Canada here. This is a chart of all the different probate fees across Canada. Let's focus for the most part on Ontario. So in Ontario, let's say someone dies with $1 million estate. There is a probate fee that used to be, until last year, 0.5% on the first 50,000, and then 1.5% on the amount above it. This year, they've actually removed the estate administration tax on the first 50,000. So effectively, what happens now is that there is a tax on 1.5% of the value above $50,000. So the reason we get probate is to have an ease of administration of the estate, to allow third parties like financial institutions, banks, and trust companies to be able to pay that money out to the proper beneficiaries. The problem with the estate getting probate is that they do charge the 1.5% tax. There are all kinds of issues. When people talk about probate planning, they say, oh, well, let's just make the account joint. If we make it joint, then it goes to the right of survivor and it goes outside the estate, and we can save the probate tax or the estate administration tax in Ontario. There's a whole list of issues why I strongly discourage you. If you get anything from this seminar, I strongly discourage you from making your account joint with anyone other than your spouse or partner. I think if you're going to do it, make it joint with a spouse or partner, I think that's fine. But I think if you make an account that's yours, joint with an adult child, you've got issues like, is that a disposition for tax? Can you lose control of the assets? What if the child gets sued? They have a creditor. What if the child gets divorced? There's a family law claim on your money. What if they are subject to government support, and then this asset is included in their list of asset benefits, so they lose asset income tested benefits, asset tested benefits? What if they already own a principal residence and you're putting your house into their name and joint names? And what about fights that can happen later on after you're gone, where you put one kid on the account, but the other kids are living across the country and their names aren't there? And then do they have an obligation to share the money later on? So it's a big mess. I don't like joint accounts for anything other than a spouse or a partner. From a tax perspective, when you die, there's 2 main implications. Number 1, there's a deemed disposition of all your property at fair market value, your stocks, your bonds, your real estate. Real estate other than your principal residence, you're allowed 1 principal residence tax-free, either while you're alive or upon death. It's 1 per couple. And then there's a tax payable on any capital gains resulting from this deemed sale. There is also a fair market value inclusion of all of your RSPs and RIFs on the day you died, unless it qualifies for a rollover. So if you have an RSP or RIF, you can roll over your entire RSP or RIF to the surviving spouse or partner and defer tax until the second to die. In a rare situation where someone dies with an RSP or a RIF and they have a dependent child or grandchild, if they're under the age of 18, you can actually buy an annuity, assuming that they qualify and you support them, which allows them to defer the tax over a number of years up until age 18. If you do have a child or a grandchild that's dependent on you, and they have a mental or physical disability, then you can roll over the entire RSP or RIF to that child or grandchild. There is an income test, meaning that child or grandchild must have income below about $20,000 last year. And then finally, if you leave your RSP or RIF to anybody else, friends, neighbors, me, adult children that have a disability, there is no rollover available. It will be taxable in the final return for the year of death. The easiest way to avoid taxes on death, of course, is to have a spouse. So if you are married or you're living common law, by leaving everything, even outside of your RSP, all your assets to your spouse or partner, there's an automatic rollover on death. There would be no capital gains tax to pay, and the result is a deferral until the second to die. So that's the easiest strategy if you have a surviving spouse or partner. Another thing you could look at is, if you want to avoid this capital gain deemed disposition on death, is pre-gifting. In other words, gifting while you're alive. There is no restriction at all in Canada on gifting. Unlike the US, which has a gift tax, which imposes a tax when you make gifts beyond a certain amount to individuals. And the rules are different in the US if you have a spouse or children or other giftee. But in Canada, we have no such gift tax. So again, there are two types of gifts, cash or property. Easiest type of give is cash to give. If you're giving property, then you could have some tax issues, right? Because if the property's gone up in value, I'm thinking you want to give that cottage, you want to give that vacation home to the kids, that could be a potential disposition and give rise to immediate capital gains tax on the day of the gift, rather than having that tax payable later on death. But again, there may be opportunities for income splitting. So again, if you've got kids in lower tax brackets, making a gift to them now is a tax-free gift. It's not reported anywhere, there's no limit, but maybe they can then take that money, invest it, and they're in a lower tax bracket. If you're going to give it to them anyway, why not give it to them while you're alive? You get to see them enjoy the property, enjoy the money. The biggest problem, of course, is that when you make a gift, it's often very hard to get it back later on. So you better be 100% certain that you can afford to do it, because once you've given up that gift, you've actually relinquished ownership and control, and you've lost that property or you've lost that money. Now, what about life insurance? Who needs life insurance? Well, look, it depends on your age and it depends on your stage. So I'd say, look, you should have sufficient insurance to provide any expenses for yourself and your dependents in case of death or even disability. In fact, I often suggest that disability insurance, if you don't already have it through your employer, is probably the #1 thing you should buy before life insurance. Look, everyone dies eventually. The chances of a premature death is pretty rare. The chance of getting a disability that makes you lose income while you're working is much higher than dying prematurely. So I'm a big fan of disability insurance, something you want to look at if you don't have it through work. Long-term care insurance, not that popular in Canada, would pay the cost of your long-term care. Critical illness is becoming more popular if you get a critical illness. But the biggest emphasis, I think, is on life insurance. Particularly if you've got young kids, you want lots and lots of cheap term insurance so that if something happens to you, that will enhance the value of the estate and replace the income. For more complicated, sophisticated strategies, a lot of our clients are looking at things like permanent insurance, whether that's the use of a universal life or a whole life policy. There are some significant tax sheltering opportunities within that policy. And in fact, if you are considering making let's say a significant charitable gift, often a permanent life insurance policy can be a very tax effective way of leaving a significant legacy to a charity or a foundation after you go. So I think insurance can be an important part of people's estate plan. Step number 4, keep track of your accounts and your important information. So here you want to make a listing of all your assets, your account numbers, etc. And you want to put a copy in a safe place, which, by the way, is not your safety deposit box. You know how many people die every year and they leave all these safety deposit boxes because they move from here to B, A to B, and they don't know where the safety deposit boxes are. In other words, you want to make a list of where your safety deposit box is located, with the address, the key number, the box number, and that goes on the list. If you put the list inside the box, no one's going to find the list, right? So you want that list, safe place, either at home in a secured safe or in a secured location, in your filing cabinet. You want to tell your executor, of course, where that's located. And then finally, I think that the most difficult thing to do of all is step number 5. And that's to review, update, and share your plan with others. Look, we tell our clients you should be reviewing your estate plan every single year. No one listens to us. It's too complicated. No one has any time. So every 3 years, again, we're ignored for the most part. I would say, look, as your life changes, your estate plan needs to change as well. If you get married, if you get divorced, if you have another child, if you decide you want to disinherit one of your kids, each of these is a reason in and of itself to update your estate plan. The other thing that's important to do, of course, is to share your plan with other people. And that's very hard. And I say this is really important, especially with your beneficiaries. You don't have to get into detailed discussions with your kids of how much you have and how much you're leaving them. And what I would recommend, though, is have some type of general discussion with the kids, especially if you're going to do anything weird. And what I mean by weird is not treat the kids perfectly equally. You don't have to treat them equally. It's not required under any kind of law. There are certain rules if someone is independent and has a disability and things like that, but there is no obligation to treat kids equally. However, I can tell you numerous stories of families that have fought for years, 20 years or more, because of a disagreement on why dad left kid A more money than kid B. Did he love A more than B? What was the issue there? So I think if you're going to do anything weird, like not treat kids equally, I would have that discussion in advance. At the end of the day, if they're going to be mad at anyone, at the end of the day, let them be mad at you. At this point, you're dead anyway, so you don't care. But why have them be mad at each other? And I think that's something that you want to consider. And then finally, work with a team of professionals. I can't emphasize more strongly the importance of having a team of professionals work together. Whether you have a lawyer that's working on the legal side, you have a financial advisor that knows all of your assets and knows all the different tax positions and RSPs and TFSAs and all the things you have, and ultimately bringing in the accountant. It's only when you have a team of people working together that you're going to get the best possible result. So again, I think it's important. You don't have to do this on your own. In fact, I would recommend that you don't do this on your own. When you're looking for a lawyer, there's lots of great resources out there in terms of who you can use. I wouldn't ask the real estate lawyer who just closed your house or condo to do your estate plan. I would have a specialist who deals with estate planning, that does wills full-time for a living. That's all they do. That can really meet with you, understand your needs, make sure that your will, your estate plan, and even some tax strategies are up to date. And again, as I mentioned, finally, share your plan with other people. So in other words, if you're going to name your neighbor as the guardian for your minor kids, probably a good idea to tell them in advance so that you don't show up one day, someone doesn't show up with 3 screaming children at the door. You want to discuss that in advance, right? Communicate your plan with others, tell the executive who they are, make sure that they want to act, keep all that in a safe place. So in summary, we have covered as much as we could in about 20 minutes. And at this point, we're going to open it up for Q&A. We have lots of information available online. So our CIBC website has, of course, all the information. And my own website, jamiegolombek.com, has a list of every article I've written in the last 20 years. It's all searchable, as well as over 100 publications that we have written on every area on tax and estate planning. So, Christian, back over to you, and we'll open it up for some questions.
Wow. Thank you so much, Jamie. So much great info and lots of things I've got to work on. So here's a question from Anika. Is there anything younger people in their early 20s, for example, can do to start their financial life off right? When is it too early to start estate planning?
So it's a great question. So in the area of estate planning, I would say that it really becomes important when you have any kind of assets or any kind of dependents. So if you're still single, you got no one, no spouse, no partner, and no kids, unless you've got significant assets, if something happens to you, it'll go to your parents. So if you're okay with that, which most people are, that's fine. If you'd rather the money go to a sibling, or you'd rather go to a niece or a nephew, you should have an estate plan right away. If you don't have any money because you still have student debt, you don't need an estate plan, right? Because it's not an issue. In terms of getting started on the right step for financial planning, I would work with a financial advisor. There's lots of opportunities out there, from investing in a TFSA, from using an RSP, from paying off student debt. We'll help you with that. So again, certainly welcome. I work for CIBC. We have some great advisors. If anyone wants to reach out to me personally, I don't do the advice myself, but we'll certainly get you in touch with somebody. But at the end of the day, I think that's where you want to start. So if you're already working with an advisor, that's fantastic. Go into your local branch or speak to your advisor, because there's lots of opportunities to get a head start, even in your younger ages.
That's great. Here's a question from Brenda. Brenda lives in the United States and has assets both in the US and in Ontario. Should Brenda have 2 wills?
So we get the question all the time. Ideally, the answer is yes. It's not absolutely required, because you could take a US will and get probated here in Ontario. That's very common. But depending on the value of the assets in Ontario and the complexity, we often recommend that it's probably a good idea, if you're going to be up here anyway, just to get a simple will that covers the Ontario assets. It's absolutely not required, but I think it's good practice. And if you can afford to do it, it'll make things simpler later on.
That's great. Does the power of attorney have to be Canadian? This is a question from Gerald.
So generally speaking, we do recommend that. It may not necessarily be required, but it depends on whether the institution is going to recognize it. So in other words, I don't think it's absolutely required, but I think most institutions would feel more comfortable working with a power of attorney that was done either in the province where they're located or certainly in Canada. So again, that's something that I'm not a lawyer, so that's something that I would check with your lawyer just to make sure.
Okay, so here's a question that I think I've heard before. Um, uh, it's from Catriona. Do you have to create a will with a lawyer? Can't you just write your wishes down on a piece of paper and have a witness?
Absolutely. First of all, you don't need a witness. So if you are doing your own will in Ontario, you can do it all in your handwriting and sign it, and it's done. That's it, right? Don't type it; it's not valid. It's crazy, right? They're very old, they're very antiquated and antiquated, and you got to be very careful. I strongly recommend against it. Look, as an emergency measure, at the end of this seminar, scribble a will on a piece of paper if you have nothing, put it in a desk drawer. But then you should try to make an appointment with a lawyer because there's so many things that can go wrong. Remember an old story that someone told me years ago that someone basically did their own will by hand and they said, I leave all the money in the bank to my kid. And then the question became, well, what do you mean by money in the bank? And when the person died, there was a fight. Does money in the bank mean the cash in the checking account? Or did the father mean the $1 million of GICs that were at the bank?
Right.
So what does money in the bank mean, right? So again, this is an issue that I really think it's worth it. Like I won't criticize you for spending money on lattes or whatever you like to do in your free time and subscriptions to online streaming. I don't know what people are spending these days, but I can imagine this is a one-time expense. You do this now, you don't have to look at it for years. If it costs you a few $100s for a simple will, it's a great investment.
That's great. This question is from Lorna. In the case where you have, let's say, no family or any friends who want to serve as an executor for your will, are there professional companies that perform this function?
Well, absolutely. So there are many, many trust companies in Canada that will do this for you. They often deal with larger estates. Some might deal with smaller estates. So for example, CIBC has a trust company. We are in the business of managing people's estates. So certainly if the amounts are significant, and really most of the big banks will only look at sort of seven-figure estates, the $1 million plus estates, just because of the cost, it's not worthwhile to go lower than that. But if these estates are smaller, there may be other smaller trust companies. A lot of lawyers are in this business of administering estates. They may be able to do that for you as well. Ask around.
So this question is about charitable giving and tax implications around charitable giving. On your estate. Do you have any thoughts on how best to work with an organization like Ryerson, a charity or others, on estate planning?
Well, absolutely. Well, the good thing about Ryerson, like many of the major charities across Canada, is that they have a team of professionals that understand charitable giving very, very well. So again, what we would do is typically come in, we'd look at your situation, understand the assets that you have. For example, let's say you've got appreciative securities. Those could be shares, they could be mutual funds, bonds, things that have gone up in value. There's a significant estate opportunity there if you leave those to charity versus just leaving a gift. Because by leaving those to charity, your estate pays no capital gains tax at all, zero on the appreciated gain. And not only that, the estate gets a receipt for the fair market value of those shares, and then can deduct 50% in terms of the tax savings. You get a 50% donation credit, depending on the province that you live in, for any amounts over $200 in a particular year. So again, there are certainly opportunities there, as I touched on earlier, even with life insurance, where if you work very closely with the charity, they have a team of professionals. They don't charge you anything, no obligation. They'll come meet with you. Maybe in COVID-19, they'll do a Zoom conference with you. But they're very, very open, just to have an open discussion. There's never any obligation, and they'd love to talk to you because there are really some significant tax opportunities, even with RSPs and RIFs, where you can cash the money in and effectively give it to the charity and actually have a lower tax rate on the withdrawal than on the charitable gift. And I've talked about that in some of the other seminars that I've done.
That's great. Listen, there are about 10 more questions in the Q&A that we're not going to be able to get to. It's already time, but Jamie, thank you so much for being with us today. So many amazing tips and perspectives that we should all be paying attention to as we think about our future plans. So thank you very, very much for sharing all of those with us today. And for all of you who've participated on this webinar, thank you so much for making the time. As I mentioned earlier, we are taping this, so you will get a recording in your inbox in the next day or so. We also have at Ryerson a guide on planning your will, so we'll be sure to include that in that email, as well as the links that Jamie referred to in his presentation to his site and to some of the work that he's been doing. So really appreciate all of you for joining us. Jamie, thank you again. It looks like we might need another webinar with you in the near future.
Right. Sounds good.
All right. Have a great day, everyone, and we'll be in touch again soon. Bye for now.